just saw a message right now. He was in the hospital apparently yesterday, and he cannot be here this morning.
Okay.
No response, John.
So his bond, what I'll do, I'm going to forfeit his bond for non-appearance and
This is a critical moment right here. When a defendant doesn't show up, the judge has very limited patience. Bond forfeiture isn't just a warning, it's a serious financial and legal consequence. But notice the door she leaves open. Hospital proof could save him. The real question is, will that documentation come in time, or did he just lose his bond entirely? What do you think? Legitimate emergency or last-minute excuse?
set it at 100,000. If he gives you, I need some confirmation that was in the hospital or still in the hospital or something. And then I'll recall that. So he needs to get that to you pretty quick.
Yes, ma'am.
Okay, thanks. Deshandra Joseph, Mr. Rojas. Good morning. You're Deshandra Joseph. And this is 24 DCCR 0708. Ms. Joseph is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
We signed a rejection.
Oh, is there something on the tablet? Can y'all check the tablet, please? Oh, great.
Here it is.
Okay. So, again, Ms. Joseph, what you're charged with is a state jail felony offense, and that's from February.
This is where things get real. Rejecting a plea deal means gambling everything on a trial. A 4-year deferred probation offer is no joke. Walking away from that is a huge decision. The judge is crystal clear. Once this goes to trial, the deal is gone. No takebacks. Would you risk a state jail sentence to fight this in court, or take the deal and move on?
20th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment could be between 6 months and up to 2 years in a state jail prison. Do you understand? Yes. And I think I'm about to have something, maybe. What? It's gone.
Four different.
Oh, okay. I was about to say it can't be that. Okay, and so somewhere there is a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 4-year deferred probation. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. Do you understand all of that? Yes. Also, I want to make sure you understand that once I put your case on the trial docket, then I won't accept this plea agreement after today. So if there's unless there's a change in some information that your attorney or the state's attorney gets. Do you understand that as well? Yes, ma'am. And do you want to reject that offer and have your case set for trial? Yes, ma'am. Okay, we'll get it set for trial. And Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him. I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? Yes. All right, so Mr. Rojas, you're released. Ms. Joseph, if you'll have a seat over here on this side of the courtroom, the clerk will call you up in a few minutes with that information. Yes. And so do we have it? Yes. You've got it? Okay. Good morning. You're Anthony Williams.
This is probation with a razor blade attached. 10 years hanging over his head, 7 years of supervision, and one mistake sends him straight to prison. Judges often explain it calmly, but the stakes couldn't be higher. Probation sounds lenient until you realize how fast it can turn into a full prison sentence. Drop a comment. Do you think probation sets people up for success or failure?
And Mr. Williams, this is cause number 24, DCCR 0401. You were previously in court, entered a plea of guilty to evading detention with a motor vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Mr. Smith?
Yes, Judge.
Any additions or corrections?
No, Your Honor.
All right, then, Mr. Williams, I am going to find that you previously entered your plea of guilty freely and voluntarily. find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but I'm going to suspend that and place you on probation for 7 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence, while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, and you could be looking at that 10-year sentence that you were already agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rowe.